Hello, everyone, and welcome to today's webcast, The COVID-19 Bankruptcy Boom, Preparing for Restructuring Discovery. Before we get started, a few housekeeping notes. All of your lines have been muted to reduce background noise, but please feel free to shoot us questions throughout the presentation using the questions feature that should be on the bottom right-hand side of all of your screens. Today's presentation will be recorded, so if you have to step away from your desk, don't worry. We'll send out the full recording after the conclusion of today's live broadcast. I see a few folks are still joining, but we want to be mindful of everyone's time. We know you've set aside a full hour for us, and we very much appreciate that. So let's get started. We've got a wonderful roster of experts for this discussion today, and our moderator will be Eric Schultenover, Executive Director at Legility and co-lead of our Enterprise Legal Solutions Group. Eric?
Thank you very much, Sarah. Good afternoon, good morning, everyone, depending on where you're joining us from, whether here in the States or beyond. Thank you all very much for joining us. We really appreciate it. On a personal note, thanks for giving me an excuse to put on a tie for the first time since March. For the record, coat and tie does go very well with cargo shorts and flip-flops, but I will spare you all the visual on that. Seriously, there's been significant interest in Legility's webinar series that we've been doing really since the spring and going throughout the summer. But this particular webinar has garnered the most interest from a registration perspective. And while I'd love to take personal credit for that, I think it's because the subject matter is so germane to what's happening in the country and the world right now. Bankruptcy and restructuring is certainly one of the busiest areas of legal practice in the wake of COVID-19. I think back to the post 2001, September 11, 2001 period and the bankruptcy and restructuring work that occurred for the next 5 to 10 years following that particular event. And I think there's a consensus building amongst experts in this particular area and folks in the finance and business communities that this particular situation is going to be far more far-reaching, I should say. So no matter the perspective that you're bringing to this particular webinar today, whether you're perhaps preparing or thinking about a potential restructuring situation, if you're a creditor, a lender, an investor to a distressed company, if you're a customer or service provider to a distressed company, chances are good that if you've not already had to deal with a bankruptcy and restructuring situation this year, you will probably deal with one in the year and years to come. So I think we've got a great group of folks here that are going to talk about some of the emerging trends in bankruptcy generally, but then also with respect to large data and eDiscovery in bankruptcy. A bit on my background personally before we jump in. I've been with Legility Counsel on Call since 2011, but prior to that, I was actually a bankruptcy and restructuring lawyer myself with Waller Lanston firm in Nashville. That said, I'm nearly 10 years removed myself from active bankruptcy practice, and a lot has changed. I can honestly say that in the words eDiscovery, large data management, never really came up in the 12 years that I spent doing restructuring work. But a lot has changed in the last 10 years, and those are very front of mind and situations and issues that companies that are going through a restructuring process need to deal with, their data footprint and eDiscovery and how that works its way through the process. And so our panelists today are going to talk us through that and have some good discussion around that. There will be a period of time at the end that we'll reserve for questions. So please do send those in to Sarah, and she will be forwarding them to the group, and then we'll make time certainly to address those if time remains. We were talking as a panel prior to this as we were preparing about there being really hours and hours worth of material here. So we'll try to be mindful and give everybody some good material and things to take away from this particular discussion. But this is something that could perhaps spawn further discussions even beyond this 1 hour that we have here today. So without further ado, I'll introduce our panelists and we can get into the discussion. The first panelist that we have is Christine Payne. She is a partner at Redgrave in Austin, Texas. She is the leader of the Restructuring Discovery team And Redgrave is a firm that specializes in complex commercial litigation from an eDiscovery perspective, oftentimes pairing with outside merits counsel, handling a lot of the large data and eDiscovery issues that arise in those particular types of matters. And so, Christine, thank you very much for joining us here today. We look forward to hearing from you on these very topics that we're talking about today. Next, we have Jason D Juncker, who is a partner with Brian Cave in their Chicago office. He is a partner in the Restructuring and Insolvency Group, and he's the co-leader of their Special Situations team. So, Jason, thank you very much for being with us here today. And lastly, we have David Wesch, who is a colleague of mine at Legility. He leads our information governance and litigation hold services group. Prior to this, he was with Cigna HealthSpring as a leader in their information governance division at HealthSpring, and brings a boots on the ground IG perspective to the panel here today. So thank you very much, David, for joining us. And with that, let's start with just a general discussion about the current state of bankruptcy in the United States, the capital markets. Jason, perhaps we'll start with you as a bankruptcy and restructuring expert. What are you seeing trend-wise? We're obviously seeing a lot of news about retail and oil and gas companies that are currently in bankruptcy, but perhaps maybe touch on what's next from your perspective, and then just a little bit more about the current state of bankruptcy in the country generally.
Sure, thank you, and thank you for putting this presentation together this morning. So, it was interesting. I was looking at some media information and some publications this morning about the current number of filings, major filings in the United States, just to get a little feel for what we would be talking about this morning, because it's sometimes interesting to look at the information all at once. The number of significant cases that this particular publication is reporting were roughly 80. Out of that 80, only 2 of them were Chapter 7 cases. The vast majority are Chapter 11s, and the vast majority are either in one of 3 different categories: retail, hospitality, including restaurants and chain restaurants, and oil and gas. But we're definitely seeing some activity in healthcare. Healthcare is going to be a big piece going forward. And basically any type of entertainment business is also unfortunately a potential filing target, including travel as well. I should say travel and entertainment are both. Companies like Cirque du Soleil have already filed, right? That's not one that immediately jumps to people's minds. Hertz and the car rental companies, I think we're all aware of them filing, but it doesn't necessarily wrap tightly with the the retail and oil and gas and hospitality piece. But everything and anything that has been impacted by COVID-19 is and has been an unfortunately ripe target for insolvency proceedings. If you were to look deeper into the information, you would see that we're sort of at somebody described it recently as the second inning maybe of a 9-inning game, as we look at sort of insolvency and the likelihood of additional companies sort of needing to enter into insolvency processes, not just bankruptcies, but sales, out-of-court workouts, et cetera, et cetera. I do think we're probably in the second inning. We might even be bottom of the first inning if you start to look at sort of all of the activity that's coming. It's interesting. You even look at debt that comes due. We're seeing a significant number of companies that are facing upcoming trigger dates on debt particularly at the end of the year, but also at the end of September and November. So the number of additional filings, I think, is going to be fairly substantial. It's going to cut across the industries we've already talked about, but it's also going to hit, I think, a number of other industries, unfortunately. Small businesses are definitely going to be impacted, but commercial real estate, for the most part, other than in the hospitality field, has saved its powder or hasn't really been implicated as much in most of these processes. Unfortunately, I think between senior living and commercial real estate, we're going to see a lot more entities needing to go into insolvency processes. The commercial real estate piece on the office side is particularly, I think, subject to weakness. Right now, we have not seen as many office tenants not paying their rent, but we're seeing more and more of that, particularly with the current occupancy rates at most businesses. Someone recently told me that the estimated occupancy rate, not rental rate, but actual people in the seats during the workday in the city of Chicago, in the Loop, downtown Chicago, is 4%, which if anybody's walked through the city and gone into the office on a Tuesday to pick up their mail, it looks like it's about 4%. There's no one on the streets. None of the restaurants are open. Hotels are barely open. It's a ghost town. And I'm imagining you're looking at the same situation, not just in Chicago, New York, LA. You're also looking at situations like this in Milwaukee, Minneapolis, St. Paul, Pittsburgh. It's a common sight, I think, across the United States, and I think many businesses are already planning on staying shut down through April, May, June. All of that, I think, is ultimately going to impact our economy and ultimately impact the number of insolvency proceedings we're going to see over the next 9 months.
Yeah, I think we're absolutely seeing those trends even here in Nashville, a smaller town. When you go up and down the streets in downtown, it's a very similar situation. Apart from some of our bars and clubs that unfortunately are still full. Seems like getting a lot of national press, probably in a negative.
Yeah.
That's very interesting, I think, from certainly an industry perspective. Can you give a little color, perhaps, though, on where the other constituencies are in the bankruptcy process? Maybe the credit markets, the lenders, the landlords. Perhaps it's too early because we're in the first and second inning of this ball game to really see where those folks are going to start coming down. But are you finding that those other constituencies in the bankruptcy cases are prepared, or are they preparing, or have they been caught a little flat-footed by this particular circumstance? Just what are you seeing?
I think it's a combination of both. I think the landlords are already preparing. They're already involved in many of these cases. One thing that has definitely been a new arrival into the bankruptcy scheme is what is likely a new first stay motion, which is basically a motion to not have to pay rent. Historically, everyone has had to pay rent within bankruptcy cases as long as you were continuing to lease property. That was an administrative expense, and if you didn't pay in a timely manner, you gave your landlord the ability to run into court and basically evict you, get stay relief and evict you, or at least compel what would be called a rejection of your lease. That's not happening anymore. The majority of, particularly the retail tenants that have gone into bankruptcy, have sought relief from their landlords to not have to pay rent, even in situations where they may have had the cash to pay the rent. They have, generally speaking, been not seeking payments on rents, and courts have been allowing it. It does go against the bankruptcy code, but it's not unreasonable for a judge to say, if I don't grant this case is going to go belly up very quickly. It becomes administratively insolvent in a very quick period of time, and you're basically taking a substantial portion of the cash and draining it and paying it over the landlords. As somebody who represents lenders for the most part, I kind of prefer judges not to enter those orders because that's damaging my lender clients. When the landlords aren't getting paid, the lenders aren't getting paid. And that pretty much stretches across every industry. It doesn't matter if you're lending on real estate or if you're lending on assets. At this point, if somebody's not getting paid, it goes up the chain. And ultimately, what we've seen in probably every downturn is the lenders are typically the parties of last resort. They're the ones that ultimately get hit with the biggest amount of damage in many of these cases, just because of the way we sort of allocate risk. And the current efforts are definitely allocating risks against landlords and against lenders, but I'm not entirely sure there's a lot of choices there.
Mm-hmm. Mm-hmm. Are you finding any sort of emerging appetites amongst landlords or lenders yet to rationalize these capital structures, to take write-downs, or to move these things rapidly to sales? Or are we still in a bit of a wait and see mode, perhaps because of continuing government support of certain industries and stimulus and things like that? Or what are you seeing there?
I think we are a few months away from real sales activity. It'll be interesting to see what happens as we approach the end of the year. When lenders particularly have to start thinking about their own balance sheets and whether or not they want to hold certain obligations going into the next year and want to pay the fees and costs, including legal, to collect on assets and what the assets are ultimately worth. We're not seeing a ton of activity there. There is some loans getting traded. A lot of the debt is difficult to trade right now because of restrictions on transactions and things like CMBS or CLOs or some of the debt structures that are out there that have sort of, in many ways, replaced sort of mainstream lenders in many instances on a lot of different assets. But I think you are going to see a lot more transactions as the year progresses and as we get closer to the end of the year. The difficult part, of course, is pricing things right now is incredibly difficult. How do you go out and how do you appraise a piece of machinery and equipment, or how do you appraise receivables, or how do you appraise real estate right now, not knowing where we're going to be in 6, 9, 12 months? I'm cautiously optimistic that appraisers are going to be willing to give sort of two different sets of opinions, an opinion now and an opinion sort of almost like a stabilized asset post-COVID. But it's hard to know when or if that's going to happen in the next year.
Mm-hmm. Christine, what are you seeing in terms of your practice specifically, and with the uptick in bankruptcies? I would imagine you guys are starting to see a lot more action on your front from maybe a data management and discovery perspective, and want to move to get into some of those topics, because that's certainly the focus of the panel here today. So what are you seeing specifically?
Mm-hmm. What we're seeing is lots of clients that are looking ahead to some of the date triggers that Jason mentioned and really trying to evaluate whether cash flow is on the horizon one way or another, and hoping to avoid filing at all, or if they do file, go in as a very reasonable Chapter 11. And so that is a real opportunity for folks to take stock of their data management and get ready, such that if they do need to either enter into very quick negotiations, or they end up in a position where they are filing later in the year, that they are ready for it and best positioned to move quickly through the process.
Yeah, maybe touch on that a little bit. I mean, obviously, you've been an eDiscovery and a data management expert, both inside of bankruptcy, outside of bankruptcy proceedings, and restructuring proceedings. Talk about the differences between maybe a conventional eDiscovery matter that your firm might be handling versus the process that you go through with a client in a bankruptcy and a restructuring scenario.
Yeah, I mean, the main difference is speed. There are kind of rules and regulations in place that tie back to the federal rules. There are some kind of nuances within the bankruptcy rules that give you different mechanisms. But the basic idea is that if there are data or documents that need to be conveyed to a party, we need to move really fast. What's interesting about bankruptcy or restructuring contexts is that most discovery is going to be done by agreement and driven by the parties. And so that's very different. If you are a typical civil litigator and you've done discovery there, it feels different, because in that sphere, discovery would be governed by the rules and managed effectively by the court. And so if there is a disagreement, you try to work it out. You might brief it, you might talk about it for several months. At some point in time, it gets teed up maybe for a magistrate, and then they send you back to try to work it out. It's just a long process. In some large cases, discovery can take months, maybe years. And in the restructuring context, we do not have the luxury of months or years. Often when bankruptcy, or when the restructuring lawyers turn and ask, when can we get these documents out the door, they mean yesterday. And so, every moment of delay for a company that is going through the restructuring process means, one, it's a drag on the client's business, and then two, all of the various entities that are floating around looking for leverage points. Delay creates those leverage points. And so, we on the discovery side just need to be able to move as fast and as accurately as possible for companies and to kind of keep pace with the bankruptcy team.
Mm-hmm. I know that when I practiced in the area many years ago, understanding your contracts, your credit agreements, your leases, those were and I know still remain critical aspects of understanding your data from a debtor perspective. But in the last 10 years, there's obviously been an explosion of all kinds of other data sources. What are the other data sources that you are guiding and counseling your clients to collect and maintain as part of the restructuring effort, particularly in these more complicated cases that you're working on?
Mm-hmm. Well, the list of data sources involved in restructuring matters is quickly growing. At the very beginning of eDiscovery, even though we all knew about email, there were some large cases where effectively we didn't talk about email, or definitely not text messages, but there was no particularly good reason why. It was just that there was something of a gentleman's agreement in place to say, we're not going to deal with that. We're not going to go down that road. And I think that type of approach has persisted in restructuring for a lot longer than in civil matters, or in typical civil litigation. And so it used to be, basically you were looking for key deal documents, board minutes, board materials, but maybe not email. Now email is a regular part of it. And, we're kind of starting to move down the road that, typical civil discovery has moved down as well. We're looking at text messages. We're looking at, larger financial systems. We're looking, kind of depending on the industry, really at the way in which any group is communicating or where they are storing their critical data. And so structured systems are coming more into play. And that, that can be a real challenge for a company that is already strained, to devote the resources, the business level resources necessary to help get those data out and analyzed correctly.
Mm-hmm. Yeah, that's certainly a change from my time of practice. Jason, I thought you made an interesting point when we were preparing for this, though, that there's the other constituencies in the cases, not just the debtors, who have to be mindful of some of these new data sources as well. And I know you do a good bit of creditor representation as well. So maybe talk us through a little bit about how you're working with your creditors and your non-debtor constituents in bankruptcy cases from a data management perspective as you deal with debtor cases.
So, what I find is that lenders oftentimes don't recognize that they are really sort of litigation and discovery targets whenever one of their borrowers goes into financial distress. It's particularly an issue because many borrowers, or many lenders, I should say, are regulated. So not only are you basically preparing things for sort of discussion with your lawyers, but you're also in many instances preparing documents that are provided to auditors and other governmental agencies that are kind of looking over your shoulder, particularly if you're a bank or many other kind of financial institutions that are subject to oversight and scrutiny. So the information that you provide in those types of, whether they're filings, their emails, their communications, whether they're with, directly with investors or fiduciaries or any other parties that are involved, those are all discoverable. And in many instances, you're providing sort of updates on value, chances of recovery, in certain cases, limitedly, litigation strategy. All of that stuff is discoverable. And so I have to, it's very important to remind clients, and most of them know the drill by now, but it's been a while since we've had a downturn. So sometimes you have to remind folks of the drill, that all of that stuff is discoverable, and depending on how you value things, for example, and what you put in disclosures, those can be used against you. If you're walking into a court saying something's worth $5 million, but you've got a report that's, from 3 months prior that says it's worth $7 million, it's going to be used against you. And more likely than not, if we go through the electronic discovery process, you're going to find that document. The interesting thing on emails, going to Christine's point, is sort of reminding people of how attorney-client privilege works as it relates to email communications. I know we've all done this on the legal side, and I think I've done like 4 or 5 different sort of CLE presentations on this topic because it's always an issue. People just think they can send a blast with, and copy a lawyer, and suddenly it's protected, and reminding folks of that is important. And then, we get into now, our other devices that we're carrying and text messages. People tend to think all their text messages have disappeared into the ether as well. But how many people are operating and texting over devices that are actually owned by or where services are provided by their companies? And in many cases, they're mandated to do that, depending on if they're, again, in a regulated industry. So, I think a borrower or a debtor in a bankruptcy case is very aware of these issues because they've got lawyers breathing down their neck every day as they're preparing for a case to say, hey, I need this, hey, I need that, I need to know about this litigation, I need to know about that contract, I need access to this data site. So they're sort of highly attuned to the issue. A lot of other parties aren't. The only other party I would mention is ownership. With so many companies owned by private equity funds these days, you are pretty much guaranteed, well, I shouldn't say you're guaranteed, but 75% of cases, if things don't look good and it's not consensual, those private equity funds are getting sued too.
Mm-hmm.
And they need to start thinking about litigation holds and what information they have and what kind of emails they've exchanged. And there's always a lot of bravado in that industry as well. So there's always some interesting things out there that that can come up, and you have to be careful about. So
some interesting emails and text messages in that community.
Yes, yes. Because these things get heated. It's heated. There's a lot of emotion involved, and people say some things that they maybe shouldn't. So lots of parties that need to be involved in thinking about discovery and electronic information.
David, I'd love to loop you into the mix here too, as somebody who's really boots on the ground and consulting with companies on the actual process and the team members that they need in place for gathering the information that's necessary for restructuring. Talk us through a little bit about the IG process, the team that you would have around you, and then we'll get into some of the best practices perhaps to follow if you have the luxury of time prior to a restructuring event. So talk about the team and then we'll get into best practices.
Yeah, absolutely. The IG team is going to be typically some of your records managers that are involved. Also your IT folks, they own the technology and they typically have a good feeling for where that information is within the organization. Along with the business owners, there may be some subject matter experts and the different business application owners and those things that will also know where the information is. And so in addition to that, we obviously need to be really cooperating and collaborating with in-house counsel on who they're recommending that we really build this team, a response team. It's almost like I say it, but almost like a disaster recovery type of event that's going on, and you want to really build that team. You have all the different players to provide that cohesive look into all the different types of information that you might want to provide. So as far as some of those best practices goes, we really encourage that the in-house counsel involves the information governance team and or records managers as soon as possible. Because as Christine was saying earlier, is the speed of getting information and responding and getting that information back is much different than in typical cases. And so it's very, very important to get the IG team involved to let them know the type of information that's out there. Traditionally, in eDiscovery and those opportunities, that there's always email and maybe some structured systems that are out there in our responses. But in this particular instance, there may be corporate contracts or maybe governance, all the different types of information that we may not traditionally have been used to responding with. And so it's very important that you get the records managers and IG people just as early on as possible so they can start looking for those different types of information that are out there. I kind of look at it in a way that it's game time, right? Information governance teams are always looking at preserving information and also maybe going through some defensible deletions and those kind of things. And now we're really having to produce information that we may or may not be readily aware of. And so really get us in early so that we can facilitate that speed to delivery of that type of information.
Can I ask a quick question?
Yes.
I'm curious. How often are you seeing companies that actually have sort of full-on information governance and record management teams, and how often are you not?
Well,
I'm always curious about that.
No, that's good. It's I don't know if I can break it into percentage, but what we're seeing is that more and more companies, especially your larger organizations, have a traditional records information management team in place because they've been dealing with paper records maybe for 20, 30, 40, 50 years and those things. And so the records, what we're seeing a big shift in is that the records managers are transitioning into what we call information governance, which is more about that whole life cycle management of information and really knowing where that is and applying it into a media agnostic world. So it's just not paper anymore, but it's also involving all those digital records that are out there, when there's voicemail, emails, structured information, all the different types of stuff that are out there, that they're really transitioning into that. So we're seeing a shift in the industry that people are starting to understand that it's important, and then really putting an emphasis on the defensible disposition side. So it's not everyone has that full-blown IG team, but there's traditionally someone that is involved in understanding, especially companies that are heavily regulated, on what information they're supposed to be keeping at least. And then the IG world really starts to help emphasize it's okay to do defensible disposition. Which I also would like to bring up is that if you have an IG team, they should be also very familiar with your retention schedule. And so the in-house counsel can also be working with your IG team to help them understand is what are the different type of records that as regulatory requirements are we keeping. And so then you can start looking at getting a catalog and of understanding these are the different type of records that we're traditionally keeping with the organization, and then these we may not be looking or may not even have an idea where those are, so they can start going out and finding those. Another best practice that's out there is that information governance and even record retention folks are in that life cycle management, and so there may be processes in place that are going through and doing regular defensible disposition. And so emails might be being deleted and disposed of over a certain period of time. And so it's important to start getting and working with those information governance and records managers people to understand we might want to turn off some of those defensible disposition applications that are going on, and to be able to preserve information that we will need for the court system, maybe not.
Mm-hmm. I would agree with that. I think that most major corporations these days have someone who is at least in part focused on information governance, and that can be maybe a paralegal. But some large corporations have entire teams focused on IG, and so when I show up pre-petition, I'm pretty much the last person anyone wants to talk about, because they kind of say like, no, 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 no. The lawyers told us we weren't going to have to get into litigation. We're not doing discovery. And so my job is basically to say like, okay, yes, that is absolutely the best case scenario. And so, I just need to kind of get familiar with your team and start having discussions about where things are, because then what we can do is we can start to bridge the gap to say, what do you think you might need pre-petition in negotiations, for the restructuring team, but also, then if we start to slide towards the filing, what are we going to need very, very quickly? What can we anticipate that will be requested? I mean, You know, a lot of these things aren't rocket science. The same types of documents are requested over and over. But then also really kind of working with the restructuring team to figure out, okay, what's good for us? What do we really need to be able to make sure that we have? Let's go turn off auto delete, make sure that that
Yeah.
doesn't, you know, fall off the system accidentally, and that we have it, you know, kind of in a way that could be ready to be plucked up and slid across the table very, very quickly. You know, all of those steps, people don't realize how time intensive it is and how unique every single company is going to be. I really don't know how to advise a company, you know, to engage, you know, an expert IG team like David's team until I get in there to kind of see, you know, how are you doing? Do they have a strong IG infrastructure already, or do they need one effectively built from the ground up? And so those are the types of discussions we really want to encourage companies to start having proactively, because you know, every moment that you spend pre-petition getting ready, and you know, it's a balance, you don't want to go crazy, but if you can spend some time proactively getting ready, it's going to save you so much time, money, and heartburn on the, you know, post-petition, that is definitely worth it.
You know, guys, we're getting actually some really good questions that are coming in from some of the attendees right now, and I wanted to get to them while we're on these topics. The first, I think, just generally maybe for David and for Christine, since you're really at the front end of these cases from a data perspective, are you seeing any actual practical impacts of COVID on your ability to get people in to help collect all these records, or how are you overcoming some of those difficulties perhaps that now we're operating in a totally different just work environment from the past?
Well, just anecdotally, we had a forensic tech just a week or so ago had to chase down an executive on a golf course to be able to get email off of his iPhone.
I don't know if it's COVID related.
But it was definitely COVID related. He couldn't meet him in his office or anything, so he was driving around a golf cart out and trying to find an executive. So it is a little bit more difficult. Just getting a hold of some of the people that are there. It has certainly given us a little bit more difficulty there during the COVID time. Yes.
Mm-hmm. You know, what we've observed is, interestingly, some people and some companies keep very highly sensitive documents in hard copy still. And it just turns out that when you can't get access to the company's campus to retrieve hard copies, or you might need, you know, enhanced security clearance to go get those copies, it's been a real challenge. And so, you know, that's an example of, you know, where you really have to kind of stop and think, like, is this worth it? Is it really worth sending somebody to be physically present somewhere? You know, and so those are decisions that companies are having to make. And then I think another really big challenge for companies that have not yet filed but are in the process of perhaps, you know, reductions in headcount ahead of, you know, as part of a restructuring, you know, any employee that departs outside of the normal process, you know, instead of coming into the HR office, checking in, handing over their phone, talking about unique data sources they have, handing over thumb drives, making sure that their successors, you know, have all the data that are necessary. Those companies are really struggling to figure out what to do with, you know, employees that are separating without effectively not being in the office for several months, and then they're just gone. So these are going to be very, very big challenges. You know, I guess the latter one is going to be the more long-lasting big challenge, just because it relates to so many things. It relates to preservation, relates to your scope of collection. You know, those employees still, you know, they're still around and they still have those data walking around with them, perhaps. You know, so these types of things are very, very tricky to work through.
Certainly some new challenges to be mindful of.
Yeah, and to add to that, Eric, real quick, is that conversely, is those companies that have moved to Office 365 and have Exchange in the cloud and those things, COVID has not impacted us at all, since all their emails and a lot of their file shares and everything are up in the cloud now. Being able to retrieve those is just as easy as ever was. And so those that are kind of, you know, made that migration and go through those steps, it's still the same.
Okay, interesting. A question specifically here, any particular risk associated with software as a service arrangements in these particular situations? Not sure if that's something that Jason, you or Christine have come across, or David.
Well, I mean, not specifically COVID related, but anytime you have third party involvement in the maintenance of data, and that could be a cloud provider, or that could be something more specific, like an SAP system, that houses financial data. Anytime you have third party involvement, you absolutely need to make sure that you understand the scope of that maintenance and whether that vendor is being paid. If they're not being paid and those data are going to be lost, then you have to take steps to evaluate that and deal with it one way or another.
I will say the one issue you have, of course, is if you're not paying somebody, they may not want to provide you with services, which can be a difficult thing as you're sort of heading into an insolvency process. Once you get into the process, particularly a bankruptcy case, you can't just walk away from your contractual obligations. You traditionally have to go into court and get basically automatic stay relief in order to terminate a contract. But pre-bankruptcy, nothing prevents someone who is a data management company from saying, yeah, I'm not giving you access. I'm not giving you the information you need to file for your process if you're not going to turn the spigot back on and pay me something. So, paying the right people sometimes means a lot. That would be my only observation on it.
Interesting. I have another question from the attendees. Are you seeing a growing challenge in dealing with specific types of data, HIPAA sensitive data, PII, PHI, redactions, etc., in production data sets in restructuring matters? That's certainly something that comes up in traditional eDiscovery in litigation, but how about in restructuring in that context?
Christine, you want to go first, or do you want me to go first?
I mean, the answer is just like yes, yes to everything you just said. It's really difficult because depending on the data set, like if you have employee data, if you have customer data, all of the privacy concerns that you just rattled off are going to come into play. And, also a lot of times, especially in a liquidation situation, something that companies would like to sell are customer lists, right? That's a valuable asset. And so you then have to really start thinking about privacy regulations. And interestingly, there is a process in place where you could get a privacy ombudsman to serve in that role. But when you are trying to move at lightning speed and you're dealing with sets of documents, you really do need to be cognizant of privacy issues, because you can't, in your haste to solve one problem and to be responsive and get those documents out the door, you can't create a huge another problem where you are effectively creating privacy liability for the company that's already struggling. And so redactions take time. There are really cool scripts you can build into different analytics systems to help you with automatic redactions. Are they foolproof? No, but you can really start to take reasonable steps to address it. But you do have to know it ahead of time, and so it means some issue spotting. We see this a lot in cases that we take over kind of midstream, and it is a huge. It's almost unscrambleable if it's gone too far down the road. So you really do need to be proactive about spotting these issues in data sets, coming up with a comprehensive plan to deal with it in the way that aligns with the company's restructuring strategy, but also with privacy regulations. A lot of times companies will have a privacy officer that can come in and be part of the discussion. But there's a number of folks who will be very interested in any misstep you make on privacy.
Jason?
So I would add just an addition. Everything that Christina said is absolutely correct. I would add an additional observation, sort of based on current conditions. It's sort of fascinating to me that in a time when healthcare is probably the biggest issue this country is facing, healthcare providers across the country are facing extreme economic stress and financial distress. And so we have seen a lot more instances where both companies in healthcare and other companies are addressing it not just by looking to reorganize or restructure or whatever else, but some of them are just honestly saying, is it worth going on? And this is particularly where we are seeing some real issues as it relates to this isn't the first thing that people think about. Frankly, people are somewhat selfish. So the first thing they think about is, am I going to have to, how am I going to get paid, whatever else? But this is really becoming an issue. And I think it's going to continue to be an issue on the healthcare side as companies are winding down and aren't necessarily looking to sort of restructure, is figuring out what you do with and how much time you need in order to address some of the data privacy issues that are now going to follow on. You can't just shut down the clinic, because the ultimate thing is personal liability can start to attach when you start messing around with people's data in this space. So there always were a couple of categories. If you were going to come in and talk to a business owner and say, hey, you better pay your taxes, you better if you collect sales tax, you got to collect and pay the sales tax to the government. Otherwise, if you collect the sales tax and you pay it to somebody else, you as a officer or director of a company can pick up personal liability. So some of these data privacy issues are somewhat similar, and starting to think about sort of what you're going to do with that information well in advance is important, because you can't just shut it down.
Mm-hmm.
And if you end up, in Chapter 7, either because that's where you started or because you slid that way after an unsuccessful restructuring, and the company is engaged in hiring a liquidator, then you do have to have these conversations with the liquidator as well, because if there are, retail sites or, clinics or anything, where that is an asset and they're looking to effectively shut it down, you have to remember that there's paper files there. And so they need to have a plan in place that is defensible and isn't going to create additional liability for the company.
That's great. You mentioned, Christine, some technology tools and things like that I think, again, folks who are involved in regular litigation and regular eDiscovery practice have become familiar with, and certainly the bench has become familiar with over the last 10 to 15 years. How familiar are bankruptcy judges and practitioners, for that matter, with some of the new technology tools that exist? Are the judges comfortable with algorithms and technology-assisted review, continuously active learning, and the like? Is that something that you're seeing deployed more and more often, or is that more of a challenge to overcome, perhaps in a restructuring situation, just because of lack of familiarity compared to the regular, civil practice?
I would say that the bankruptcy world is, on the whole, less familiar with TAR than civil practitioners are. However, they're also used to doing things a lot more amicably and by agreement, and than what we see in civil litigation. And so, the answer is, if folks are unfamiliar, they can become familiar. And so, really hiring counsel that is kind of in deep in terms of the technological tools that are available, and is going to be able to explain that and get a measure of comfort with both, counsel for other parties as well as with the judge. It can happen. It just needs to happen really quickly. We see TAR being used a lot in bankruptcy context. We use it all the time. It just might so happen that we're using it in a context that doesn't necessarily need to be disclosed, like on incoming productions perhaps, or as part of maybe say an investigation by independent directors. Those are really good areas where using analytics helps you kind of cut to the heart of something really quickly. And so the instances where you see extreme fights over TAR, if you're in a typical civil case, you might see a TAR protocol get litigated for 3 months and you have to bring in experts and the judge, gets sick of you. That's just not going to happen in the bankruptcy context because there's not time for it. So you're either going to be able to agree quickly and use it, or you're going to have to move on and figure out how to do it a different way. In certain cases where things really slide off the rails and it starts looking more and more like typical civil discovery, then yeah, you might get in a situation where you're maybe negotiating bits of a TAR protocol with opposing counsel, but that's going to be in a larger adversary type of proceeding, and there's rules. So it's absolutely available. I think a lot of times I'll show restructuring attorneys kind of what we can do with some of our analytics tools, and they say, wow, that's so cool. So they're very open to new ways of doing things and kind of creative ways to get at data and what's important. But you just kind of have to always be mindful of how you're using TAR, the ways you're using TAR, and perhaps ways in which people might complain about it in the future.
Mm-hmm.
Just a quick observation on that point as well. I probably didn't know what TAR was until about a year ago, but B, I do see it more in processes, particularly since in many insolvency processes like receiverships, Chapter 7, some Chapter 11 cases, you've eliminated the party that actually had ownership over or control over the documents. So there's no one really. You might have 7 lenders or 20 different parties that want specific pieces of a larger set of documents, and you don't necessarily have anyone that wants to pay to have either their own people do it or to have a trustee or receivers people do it. So these kinds of processes I find to be incredibly useful if you have a large set of data and documents, and no one really who may have the resources to do reviews, particularly since certain people are going to want certain different things. Equity receiverships are another good example. If you have a company that's brought into a process because of fraud, who's going to do that because the other piece of it is somebody still owns a privilege in most cases in the middle of these things. So it's not like you can just turn the documents over to one of the creditors and say, oh yeah, go ahead and take a look for what you need. Because now you've opened up a whole bunch of documents that may be privileged, that are going to be non-responsive, irrelevant to what somebody's looking for. That's where I think finding somebody, in many cases a neutral, to come in and do those kind of discovery searches for you can be very practical, important, and useful, and people aren't going to complain about it, as Christine said. We all just want the information.
We talked a little bit before about preparing for a filing, and I think one of the assumptions underlying that discussion was that you actually had time to prepare for a filing. I think some folks are finding themselves, perhaps more rapidly heading towards a filing that they weren't prepared for at all. And it's more of a fire drill. In a fire drill situation, what are the really important documents that folks should focus in on first, the data sources that they should absolutely make sure that they have as they get ready for a filing? And this is really for the full panel. So David, maybe I'll let you take a stab at that first, and then we've only got about 4 or 5 more minutes, so we can just let everybody else add that comment in, and then that may occupy the last few minutes here.
No, absolutely. It's just, if I had to have kind of a final word here of what, from the IG perspective, is get us involved early on so that we can understand those types of documents that Christine and Jason are looking for. And even though there may not be full eDiscovery going on, we can at least get our arms around what it is we're looking for. We can also educate and sit down with the Christines and say, here's what we're keeping, and here's what we're not keeping anymore. And this is what's been going on because of defensible deletion and those kind of things. And so it's just really important to, once again, get us engaged as quickly as possible so that we can get our arms around those documents that they need very, very quickly.
Christine, what are you advising your clients that are absolute must-haves, and what do you do in a fire drill situation like that?
I mean, in a fire drill, you grab what you can. So transaction documents, board materials, board minutes, especially if there's not a software system in place to manage those. You're going to be looking for deal rooms or any data rooms that may perhaps once were live and have been reduced to a thumb drive that is in the desk of someone who quit yesterday. Kind of major financial systems, anything where you kind of try to figure out who are the 5 or 6 key players that you're going to be interacting with. Have we interacted with them historically? How have we done that? Has it been by SharePoint, by email? And then grabbing and locking down those systems as quickly as you can.
And Jason,
I will just add one very practical observation. The one thing you absolutely need is a list of parties, creditors, litigants, et cetera, et cetera. If you don't get notice, you're not impacted by, I mean, you can be impacted by the automatic stay, but it becomes a bit more difficult. So you need to know who is out there. I can sign an emergency petition with a very de minimis amount of information, basically a resolution saying I can file. But I need that list of creditors, because if you don't have it, then you really start to run into issues as far as getting what you really want, which is in 99% of the cases, people file on an emergency basis so they get the automatic stay. And the automatic stay is a lot less effective without notice.
well, great. Well, I don't think we've got any questions from attendees that we've not already answered. So with that, we have a few more minutes. If anybody else has anything final that they'd like to absolutely get in, one last statement, and if not, we can, I think, conclude here. Anybody on the panel have anything else final they want to say?
Just thank you so much for putting this together. It's wonderful talking to you.
Absolutely.
Yes,
Thank you
absolutely.
all very much for being part of it. And I think if there's a cardinal rule always in these types of cases, it is involve your professionals early in the process if you have the ability to do that, both from an information governance perspective, but also certainly from a restructuring advisory perspective and the data management perspective. So thank you guys all for your expertise and your thoughts. And with that, we'll conclude today's webinar. Thank you very much. Sarah?
Thank you.
Thanks very much.